Alrighty, folks. Looks like we are live. This is George. I'm a founder of Solo. I'm here with my friend Yale Levy. Yale, can you go ahead and tell us a little bit about yourself?
Yes, good afternoon or good evening, everybody. My name again is Yale Levy. I'm in Columbus, Ohio. I was a debt collection attorney for 20 years, owning a law firm called Levy Associates. We did retail collection, which is mostly credit card and auto collections. And we did that in Ohio, Indiana, Kentucky, Maryland, and Virginia, and sometimes in the District of Columbia. I retired from my practice about 10 months ago. George Simons contacted me back in September of 2024 and invited me to come work with him. It's been a fun ride. We've done a lot, talked to a lot of people, and I'm excited to be here today.
Great. So, folks, we are talking about how to respond to a debt collection letter today. We also have quite a few people who have written in with questions for us, and we have we reserve quite a bit of time for any live questions that you have that you put into the chat. So if you have any questions, just go ahead and put those into the chat now, and we will get to some of those. So Yale, jumping right in, how does somebody respond to a debt collection letter when they get one of those?
Well, number one, the most important thing is you should open your mail because they're sending you the mail, that letter, for a reason. You should open it, see what it is, and make sure it is accurate. If it is not accurate, that is when alarm bells start going off. And the sooner you contact your collector, your creditor, your debt buyer, whoever's sending you that letter, the better off you'll be because you are now expressing concern about an issue you have with the letter, be it identity theft, be it fraud, be it somebody else's. The sooner you communicate with your creditor or collector, the better off you'll be. So my number one piece of advice would be open your mail, look at the collection letter that you receive, go back in your memory and say, boy, is this mine or not? If it's not yours, stand up, communicate, and say something.
Fantastic, great. Yep. So communication is key. All righty, folks. And if looks like we have lots of people on the podcast on the hotline tonight. So if you have any questions, just go ahead and put those into the chat, and we'll try to get to those.
I see that Tiffany Cookie or Koki has a question. Is it better to use a prepaid legal service to use to negotiate on your behalf? Better than what would be my question. That is one viable or good alternative to use to negotiate. Again, most people could do it on their own by just picking up the phone and trying to communicate with their debt collector. You could use prepaid legal. That's a great service because it will be a discounted price and they do work for you because you pay probably a monthly fee for that prepaid legal service. You could also contact legal aid. You could hire a private attorney for yourself. You could call them and pick up the phone and talk to them. And also, Solo has a product called Solo Settle, which allows you or anyone who has a debt to try to settle their debt digitally without ever picking up the phone, but by communicating with them on your phone or your computer through digital communication back and forth.
Right, indeed. Fantastic. Yeah, and Tiffany, I'd weigh in. Yeah, in my experience, oftentimes, I mean, prepaid legal plans can be awesome. Oftentimes, they don't deal with certain litigation issues, and oftentimes I've talked to people who have said they've called whatever their prepaid legal plan was, and they said that they won't represent them in this kind of a situation, or they won't help them out with this situation.
Right, that
So
is accurate, George. Not all legal services plans help with debt relief or debt settlement cases. So it's pick and choose if it works
right.
or not.
Yeah, but oftentimes what they're really set up for is doing your estate planning, or maybe making an LLC for you, or doing some contract work for you, stuff like that. Okay.
But again, Tiffany,
So
you can do it yourself. Will you be better at it than them? It depends. How good you are at um, articulating what you want and advocating for yourself. If you're good at that and you're comfortable with that, it would be great to do it yourself because you care the most about your debt. If you're not comfortable with it, or you don't know the jargon, or if you think they're going to pull the wool over your eyes, sometimes it is better to have a third party or use somebody else to try to help you.
right. And with Solo Settle, we're working towards getting people instant settlements. We spend a lot of time building relationships with the consumers that work with us, also with the collectors, to help them understand each other's needs and just get to a resolution very quickly. So you can check out Solo Settle as well. We have a question from Dawn in California. So a write-in, so it's a bit of a longer question. So she says, I had 11 counts of identity theft from 2007 to 2012. That's tough. That's a tough start, huh? 11 counts of identity theft. That's a lot. Which affected an account with a credit union here in Orange County, California. The credit union was represented by Win Law Group, who filed a judgment for the unpaid credit card debt of $15,000 in 2013. We went to court despite having proof of all the ID theft, a police report on it, and an investigative report. They won the judgment. They were never able to collect or garnish wages or seize property, as I am self-employed and own no property. Yes, what do you think about that so far? Yeah, that's pretty intense, right? She's saying
Yeah,
she
it's a
got
pretty involved,
15,000.
yeah, pretty involved issue.
I'm surprised that she lost the case and got a judgment against her, even though she was able to show identity theft.
Right. Well, again, they have to prove that that credit union's account was part of the identity theft. If they did
Uh-huh.
Citibank and Capital One identity theft, maybe the credit union didn't have identity theft. Again, every case stands on its own legs, and without reviewing the documents in depth, we really can't determine what happened and why.
Right. Yeah, sounds like a bummer for you so far, Don. She says this 13-year-old debt is now being pursued by Gerstel Law Firm, and they're trying to collect on it and have filed another judgment as of January 2025. Have they actually re-aged the debt at this point? Is this possible if the California statute of limitations is 4 years, 6 years, and 10 years, depending on the form of the debt? And honestly, I have no intention of paying this debt as it was a result of identity theft.
So they did not re-age the debt because once judgment happens, the debt doesn't go out of statute, but the judgment can expire. The reason they probably refiled for judgment or renewed the judgment was to keep the judgment from going dormant. So judgments in states do go dormant. It's a state-specific law, so every state has a different timeline, and it's something that you need to look at on a state-specific basis. So it was not re-aged, but the judgment entry can be renewed by filing a motion to keep it going. And that's what it sounds like they did. So yes, they can do that, Don.
Right, right. Yeah, so it sounds like they renewed the judgment before it expired. And right, so the statute of limitations that you're citing here, Don, that's probably applying to bringing a new legal action, like starting a new lawsuit for something that happened. But the statute of limitations you need to look at is that of a judgment. Most states will have a statute of limitations on a judgment. Usually it's 10 to 20 years. We have a little calculator you can use on our site to determine that as well for California. So she goes on to say, what is the best way to stop this law firm in the tracks, absolve the debt, and not have to go to court for yet another judgment, but also so that it doesn't get sold off again to yet another junk debt buyer?
Well, there's a couple of things you could do, Don. And again, these are hypotheticals. I'm not licensed in California. I'm not a California attorney. One option would be filing bankruptcy, maybe not the ideal action, but a bankruptcy Chapter 7 would wipe out all your debts, including the debts that this credit union is going after. Another option is paying or settling the debt, which doesn't sound like something you'd want to do because you don't owe it. I guess continuing to open your mail and we go to court cases is probably your best option at this point, unless you want to file bankruptcy or try to get it settled. You could continue to dispute the debt by letting the current law firm know that this was the result of identity theft or fraud. Unfortunately, back some time ago, a judge or court had already adjudicated that the debt was valid because they issued a judgment or awarded a judgment for you. The best thing to do, if you really believe that the judgment was a result of identity theft, was try to have that judgment vacated by showing the court that it was not yours and trying again to convince them that it was identity theft and not a valid judgment against you.
Right.
That'd be a
Uh,
very difficult uphill climb, but possible.
yeah, Don. It looks like Don might be on the chat live here. So Don, if you could weigh in, I'd love more context around, what are you doing for work currently? It looks like you're self-employed. Love to hear a little bit more about your occupation, and if you could tell us a little bit more about how this identity theft occurred. 11 counts of identity theft is pretty severe. We'd love to hear a bit more context as well about the how this credit union debt really came out of the identity theft, right? Like, what do you tie it to? So I think to Yale's point, right? So you're saying that the debt stems from identity theft. It sounds like the judge in the trial back in 2013 disagreed with you. Court cases can be confusing and stuff. You might want to go back and try to find that document and read the judge's order, the judge's decision, and find out why the judge thought your debt wasn't a result of identity theft. Like, was it that the judge determined identity theft didn't happen? Was it that the judge determined identity theft did occur, but the credit union debt wasn't a result of that? Was there something else that happened? And to Yale's point, right, you might try to get the judgment vacated by further proving that identity theft did occur. Yeah, would this be like a situation for vacating the judgment, or to be a situation for appeal?
Well, again, there's very strict timelines in each state about how long you have to appeal. It seems like what happened to Don happened a long time ago. So that appeal time is probably well past.
Yeah. Says that Dawn is a self-employed massage therapist, so doesn't know how the identity theft occurred. Yeah, I would look into that a little bit further and like try to dig up, try to make sure you understand why the judge determined this wasn't a result of identity theft. You can also, collectors try very hard to be compliant and only collect on like debts that are owed. So you might try pleading your case and like essentially updating the debt with the collector as well. We do a lot of work with Gerstel, and we help people settle a lot of cases through them and get resolution. And oftentimes, collectors really are quite reasonable, and will look at evidence on these cases.
So it looks like Sarah D has a question. If
Yep.
you are on long-term disability and that is your only source of income, can you get sued? Yes, Sarah. Again, my disclaimer is I'm a licensed attorney in Ohio. I do not practice law in any of the other 49 states. I do not have a legal relationship with you. So the advice I provide you is just hypothetical advice and not actual legal advice that you can rely on. You need to seek your own attorney to make sure that you get the proper legal advice based on your circumstances. Yes, they can still sue you, but at least in Ohio and probably most other states, long-term disability insurance or payments are exempt income that cannot be garnished. So we're talking about two different things here. Yes, they can get a judgment against you if you owe them money, but they cannot take your disability income from you as a garnishment to pay that judgment. While you could voluntarily use some of your long-term disability income to pay that judgment, you don't have to.
Great. Okay. Jumping into the next question we have here. We have a video or an audio clip. I'm going to play it for everybody. And if you want to make sure that your question gets addressed here on the hotline, the best way to do that is to send us a live recording or leave a message on our voicemail.
Yes, I have a question. I had been in a debt relief program and they were deducting my payments on my account, but they weren't paying the bills. So I quit and I contacted all of the debtors I had. And so I had made arrangements for three of the debts, and then they turned and sue me. They had agreed for me to pay them in full.
Okay, so that's all of the recording we have here. So this is from Mandy, I believe. So Mandy was in a debt settlement program, and then she's saying that she found out like the debt settlement program wasn't really paying anybody. So she removed herself from that program, got an arrangement with the collectors directly, but then the collectors sued her for those debts. What does she do next? How common is that? Yeah, like what do you think about that situation so far?
Yes, there are situations where some debt settlement companies maybe go rogue and aren't paying your debts like they should. Again, you should go to your state AG or your state consumer protection agency and bring it up to their attention that that debt settlement company that you're working with is not complying with what they told you they would do and is actually harming you. You could probably also reach out to the CFPB if the CFPB is still around in the next couple of months. But I believe there are many consumer watchdog groups that would help you if a debt settlement company does not do what they promised they would do for you.
Yeah. And sometimes debt settlement firms are highly regulated because when debt settlement firms became a thing in the early 2000s, and especially after the change in bankruptcy laws around 2008, there was a bit of a sham that they ran where they would charge a consumer a subscription up front, like the consumer would pay $50 a month to the firm, and the firm would then, in theory, go and settle their debts. In addition to the $50 a month, they'd have the consumer pay money into an account, like $500 a month into an account, and that's supposed to be building up an account that then would be used to go and settle all of these debts. However, oftentimes what wouldn't happen, or what wouldn't happen, is the debts would not be settled. So in some cases, there might just be somebody actively doing a scam or a sham where they're just collecting this money from consumers with no intent to settle. That's the worst situation. And because of that, the settlement firms have been highly regulated. A lot of the firms that are operating today are in a very legitimate company that are actively trying to settle debts for people. However, oftentimes it takes 12 to 24 months to settle, right? So Mandy, you might be paying into this account for 6 months and nothing's getting settled. And maybe the settlement firm was telling you that they'd settle things faster. I don't know. But that's just oftentimes part of the program. It'll just take 12 to 24 months to get something settled. That's why with SoloSuit, we do things differently. We're operating in a way that's very friendly for the consumer, where we're just trying to, with our software, use the debt to get a resolution ASAP. Right, so as soon as you have a debt that you want to resolve, you can get on SoloSettle and select an arrangement that works for you and just get it resolved ASAP. You don't have to wait around for 12 or 24 months for things to happen. Yeah, what about the situation where she says that she gets sued, right? She had like a payment plan basically set up, but then she got sued. Is that something
I'm
that you've seen
assuming,
happen?
right? Well, I'm assuming what happened was the debt settlement company set up a payment plan with the consumer. The debt settlement company did not pay the payments that were set up, and therefore they breached the settlement agreement, resulting in her being sued because she didn't pay or they didn't pay what
Hmm.
they agreed to pay. So that again is an issue of having a third party involved, is that you're relying on them to do their job. Some of the suggestions I would have is, if you decide to use a debt settlement company, which is your right to do, and for some people is a wise idea, make sure you investigate the debt settlement company you're using, read reviews about their practices, and make sure that they know how to work and that they will pay you bills timely. They should send you monthly statements of the money in your debt settlement account and when they pay to your creditor, and make sure that you look at that every month. By what? By opening the mail and checking it and looking at your statements to see, yes, I paid in $500 and they paid out $400 to creditor XYZ. So that is the check and balance. And if they're not doing that, and you know that you had an agreement to pay $400 a month, and you don't see payments coming out of $400 a month, I would be calling them ASAP saying, what's going on? What are you doing? And if they don't address it immediately, I would reach out to your attorney general, your BBB, legal aid, consumer advocates, to raise your hand and get attention for your problem. So again, you can't sit on your hands and hope it goes away. You can't trust third parties 100%. Third parties do a lot of good work, but you need to be on top of it and validate what they're doing, and they're doing what they said they would do.
Right. And I understood things a little differently in that perhaps she had canceled the debt settlement firm and then got an arrangement directly with the collectors, and then the
Oh,
collectors sued her. I'm not sure if that's the case, but in that situation, I would think maybe there's just miscommunication with like the law firms. Maybe they didn't actually record the settlement plan. Maybe you missed a payment. Uh, I think that even if even if the consumer is on a payment plan, I mean, the collector can sue you even if
well,
you're on a payment plan actively paying, right?
no, I would say if the collector agrees to your payment plan and accepts your payments, and you make payments every time without breaching your payment agreement, they should not be suing you. They should
Is
only
there
sue you if you fail to make it or you don't make your payments.
There's not really anything stopping them from suing you though, right? Because
Oh,
you've already breached the agreement, even if you get onto
well,
a unwritten and undocumented payment plan.
but what I would assume it would be a documented payment plan. But yes, I would always ask for everybody online listening to me, listen very clearly to this. Any agreement you have with a collector, ask them to put it in writing and sign it so that you and them all know what the terms of the agreement is, how much you have to pay and when. That would be a very wise policy for everybody on this call to do.
For sure. Definitely. Yes. On to question we have here live.
How about this Lawrence one? Good evening. I am Lawrence from New Jersey. Can I negotiate my debt after judgment against me? That's a good question. I file a motion of appeal to reverse the judgment. So what do I do next? I don't really understand the second half, but I will try to address both to the best of my ability. Can you negotiate a debt after judgment? Definitely 100% yes. Now, your bargaining position is a lot less because the lawyers already spent the time and money to get to judgment and had a court of law adjudicate that money is owed, but there's still work to be done by the law firm or lawyer to do post-judgment activity. So at some point, yes, they still will agree to settle. Maybe they won't settle for as less as they would have if you'd have done it pre-judgment. But yes, do not stop since judgment has been granted. You should still try to make efforts to settle that account so that you could take control and have some input on how much you pay and when you pay. If you don't do anything, just stick your head in the sand, which many, many people unfortunately do, the result is if your state allows wage garnishments or bank attachments, they will do some kind of post-judgment action, like place a lien on your house, commence a wage garnishment or bank attachment. And a wage garnishment means they'll take up to 25% of your take-home pay, depending on what state you're in, or they take all the money in your bank account except for exempt money and the statutory minimum that is allowed to be kept in your bank account. So you don't want that to happen. Those are called involuntary payment measures, and you have no control once that happens. The second point, I file a motion of appeal to reverse the judgment. Well, if you filed a motion to appeal, that's great. I think you need to go to court and make your argument as to why you think the judgment should not have been granted, i.e. that the judgment be reversed. If it's an actual appeal, it goes to a different court, and the court then looks at the record and determines if the trial court judge made the right decision or not. If you just ask for the judgment to be reversed by the same court, the court will look at the evidence and the arguments you make and will then determine whether or not the judgment should be vacated or not. Next question.
We have this great question from Francesca that I'd like to answer. I think it is kind of a key question. Francesca says, does Solo want me to lose my defense, so I'm more likely to use Solo Settle? Isn't this a conflict of interest between your two products? So Francesca, glad you asked this. This is a little bit of a misunderstanding. This kind of represents a misunderstanding here. So Solo has SoloSuit and Solo Settle. With SoloSuit, most people are using that to create a response to a debt lawsuit, like an answer. And that is not so much your defense as it is just a first step in your lawsuit. So the answer isn't designed to have you win the lawsuit. The answer protects you from a default judgment, from losing the case automatically, but it is not going to resolve the lawsuit by itself. It is just the first step. In some situations, if you file out the answer, the collector might dismiss the case. We do see that happen. But oftentimes that's because they might realize they're suing the wrong person, or they might just want to drop litigation and try to pursue collection outside of court, something like that. But these two products are designed to work together. So you use the response to the lawsuit, that gives you a position to then settle the case. It kind of like extends your timeline to settle the case. So then you go over and use Solo Settle to get the case settled.
I totally agree with what George said. The solution to all of life's problems, including debt collection cases, is communication. The answer prevents the default judgment from being granted, but that's just the first step. You need to communicate with the debt collector, the law firm, the creditor, whoever is suing you, and try to get the case settled. If you owe the money or you don't owe the money, you still need to work on trying to get the case resolved. If you don't owe the money, explain to the law firm, the creditor, why you don't owe the money. And if you're right, they will probably dismiss the case. If you want to settle the case, I would start off in the 50 to 70% range and work your way up as they work their way down. Typically, all parties want to settle as quickly as possible. So settlement is truly the best result if you owe the money. Again, if you don't owe the money, stand up for yourself, explain why, and ask for the case to be dismissed.
Great. We have a question from Adriana. It's about mortgages more generally. She says, My fiance was approved months ago for a loan. We decided to wait and raise his credit to get a better rate on the mortgage loan. We are first-time homebuyers and reside in New York. What are some ways I can improve my credit to get a better rate on the loan?
Well, I am not a credit repair person, but I've been around it enough to be dangerous. Again, don't take what I'm saying as gospel. This is just what I know from word of mouth. Some of the different indicators are the amount of credit you have outstanding. If you pay your credit cards more often so that your credit cards do not have high balances, that will help your credit ratings to some degree. If you have any outstanding debts on your credit report, I would suggest paying those down as much as you can to try to improve your credit score. I would also recommend not taking out any new credit, because every time you take out new credit, that does decrease your credit score by a couple points. So those are some of the low-hanging fruit that I know of that would probably help you improve your credit report score. I would also say make sure you make your payments on time. That's a big indicator of your credit score as well.
Right. Yeah, some other thoughts here. So, Adriana, perhaps you come to Solo because you have some kind of an outstanding debt as well. If you do have an outstanding debt, delinquent debt on your credit report, resolving that will definitely boost your score a significant amount. So, getting that, if you have like a judgment that's going to be against you, a delinquent debt going to be against you, if you can change any of those into a settled debt or a debt that's been paid with less than the full balance, that's a win. If you can pay the full balance, that's going to be even better on your credit score. Let me go ahead and show you how you can use our product for this kind of thing as well. So if you come to SoloSuit.com/my dashboard, or if you just go to just go to our website and click the dashboard button. That'll take you here. You can do a credit check for free, so you can check your credit, see your score and your report for free. This is a dummy account, so we just have an NA out of the full score of 850. Then it shows you the factors that are impacting your credit score. So payment history is the biggest factor. So have you made any late payments? That's the biggest factor that will impact your credit score. And then credit usage is the factor. Derogatory marks, that's where these lawsuits and delinquent debts, like a debt lawsuit, will fall under. Credit age, that's how long you have a credit account open for. That is an important factor. Total accounts. So opening, you don't want to do a hard credit check right before getting a mortgage. But if it's going to be a while, like another 6 months or a year, certainly opening up some new accounts would likely improve your credit score a bit. Creditors like to see quite a few accounts, like 5 to 15, and even more than that, to improve your score. And then hard inquiries, right? So that'll be a negative on your score. Not a very big negative, but just a little negative if you get a bunch of hard inquiries before you get the mortgage. And then available credit is also an important thing. So there you go. So the main thing is payment usage. And if you want to, what is really a great thing that people are doing is they get their credit score checked for free. Then you can come in here and you can ask Solo, and you can just chat with our AI that has passed the bar and even the CPA exam, and you can get tips on how to improve your credit score right here if you just click the Ask Solo button and then chat with it. So that's a great way to get personalized tips on how to improve your credit score when you're preparing for the mortgage. So I highly recommend just going in here, doing the credit check, and then chatting with Solo to find out more about what you can do there. Alrighty, folks, that's pretty much time. We have we can maybe respond to one more live question here, Yale. What do you think?
Yeah, go for it.
Great. So we have a question from Caleb. I just filed a motion to change venue in Virginia since I now live in North Carolina. North Carolina prohibits wage garnishment. So
Okay.
it sounds like Caleb changed from North Carolina to Virginia, or sorry, from Virginia to North Carolina. The clerk said I don't have to file an answer, but I'm wondering if I still should show up.
So Caleb, I am an attorney, so I would not take the clerk's advice. I would file an answer for sure, because you want to state on the record your defenses and whether you're the debt or not. I would never just go in blind and not answer. So I say you should show up. You should talk to the lawyer that shows up, see what you can do to get the case settled. Since there's no wage garnishments in North Carolina, maybe they'll take a little bit less on the dollar because there's no other way to collect it post-judgment. So you have options available to you. I would use that information to your benefit, and maybe you could get 50 cents on the dollar or less. I don't know. Again, I'm not licensed in North Carolina. I've never practiced in North Carolina, but I would follow the answer and I would show up. I would never, to everybody on the call, I would never not show up to court. You should always be there. You should always go. You should always advocate for yourself. And you should always take notes of what was said to you and what you said to them so that you could recall and remember it down the road.
For sure. Yeah, no idea why the clerk would have told you not to file an answer. Some states have a little bit of a different civil procedure in debt lawsuits where you don't necessarily file an answer per se. North Carolina, though, is just a answer, pretty standard state. So it's one of our more popular states, really. So you can use this just to get an answer filed ASAP. And then if you get a hearing scheduled, you definitely want to show up to that, right? Not showing up to a hearing basically means that you forfeit the lawsuit, right? It's like not showing up to a basketball game. You just lose automatically, usually, especially if you're the consumer.
Exactly.
One last thing, folks. That's pretty much a wrap for today. You might have seen on our site that we have a giveaway that you can sign up for. If you haven't signed up for it already, we have thousands of people that have signed up for it. So if you're one of the people who have not signed up for it yet, you want to go ahead and do that. So Solo's debt payoff giveaway. Just go to our site and click on this banner here at the top. Enter for a chance to win up to $4,700 to pay off your debt. All right, so if you're being sued for a debt right now, or even if you're pre-lawsuit, if you're just in collections, you could win money that would go towards paying off a debt for you. And we went for $4,700 because that is the average amount that people are sued for that are using Solo. Alrighty, folks. So that's it for the show today. Again, this is the Debt Hotline. This is George, and we're here with Yale Levy. We're doing the show just about every week on Wednesdays. So we'll see you